guys, mkoaje? Hope mko poa. Pia mimi naendelea fiti. And for today niko hapa kwa sababu ya introduction to law and governance. So tunaendelea kutoka mahali tuliachia last time. So have your notebook, have your pen. Yes. Our class in a start in a while. So in our last lesson tuliandika some few notes in the topic of law of tort, na tukaguzia vitu kadhaa hapo. So for today nataka tuanze mahali tulisema tumeachia, and that is subheading yenye tuliandika general defenses in tort law. Hapo ndipo tuliachia. So kama ndio unajiunga nasi, this is a topic subtopic in a topic of law of tort, and a subtopic we have general defenses in tort law. So I hope you have your pen and a book. Tunaendelea with our notes and our class. So let's start. So under this we have several general defenses or defenses in tort law, and we start with the number one, plaintiff's default stroke contributory negligence. Plaintiff's default stroke contributory negligence. Under that, this defense may be relied upon if the plaintiff is also to blame for his suffering. The defendant must prove that 1. The plaintiff exposed himself to the danger or risk by act or omission. Number 2. The plaintiff was at fault or negligence. The plaintiff was at fault or negligence. 3. The plaintiff is negligence or fault contributed to his suffering. The plaintiff's negligence or fault contributed to his suffering. So those 3 points are some of the main examinable points. So under this unaweza ulizwa to prove if the plaintiff was blameable. So utapeana hizi points 3. So tunaendelea kuandika, this defense doesn't absolve the defendant from liability. It merely reduces the amount of damages payable by the defendant to the extent of the plaintiff's contribution. The defense is unavailable if the plaintiff is a child of tender years, so ako miaka ile ya mtoto mdogo. If the plaintiffs were to sue and the defendant proved that the plaintiff was in the wrong, that can constitute a defense. Under common law, if a person contributed to a tort that prevented him from suing, it was a complete defense. So number 2, that was general defense. Number 1, plaintiff's default. Then number 2, act of God. Act of God. Where damage is caused directly by natural circumstances which no human foresight can provide against, and of which human prudence is not bound to recognize the possibility, the defense of act of God applies. For the defense to succeed, it must be shown that the act was not foreseeable and that it was unusual. so was not expected. So calamities such as earthquakes, unaona hizo si vitu unatarajia, yeah, floods. So some of the acts of God hauwezi zuia. Defense number 3, volenti non fit injuria. Volenti non fit injuria. So the spelling is VOLENTI, non, NON, fit, FIT, injuria, INJURIA, volenti non fit injuria. This defense is available in circumstances where the plaintiff, with full knowledge of the risk, voluntarily agrees to undertake the same. So mtu anajua but anaamua kama mbaya unasema dawa ya moto ni moto. So ukisema hivyo, then this defense applies. The defendant must prove 1, that the plaintiff had actual knowledge of nature and extent of risk. 2, that the plaintiff agreed to incur the risk voluntarily as was the case. The plaintiff agreed to incur the risk voluntarily as it was in the case of Tangwell versus Barnett. So number 3. So there is no number 3. So we go to defense number 4. Defense number 4. Necessity. Necessity. It may be relied upon if the tort complained of was necessary to protect the society. It is usually relied upon by the state for acts taken to protect the society at large as the interest of the public prevail. The critical thing is that the act done has to be reasonable. Necessity is limited to cases involving an urgent situation or imminent peril. The measures taken must be reasonable, and this will depend on whether there is human life or merely property in danger. Number 5, defense number 5, statutory authority. Statutory authority. This defense may be relied upon by the defendant, into bracket, usually the state or its agents, if the nuisance, that is nuisance, is authorized by statute. The defendant has a complete defense only if he can prove that he acted in accordance with the provisions of the act. Whether the defense succeeded or not depends on the interpretation of the statute. So those are the main 5 defenses in the law of tort, and their specific torts. That's another subtopic. So under those defenses, have them in your fingertips. It's a very, very examinable area. So go through them, understand, know how to explain, know how to highlight. If you are told to highlight or explain, you can be able. So another subtopic, and tort is specific torts. Specific torts. And number 1, negligence. Negligence. And under negligence, we first start by defining what is negligence. Negligence is the omission to do something which a reasonable man, guided upon those regulations which ordinarily regulate the conduct of human affairs, would do, or do something which a reasonable and prudent man would not have done. I repeat, negligence is the omission to do something which a reasonable man, guided upon those regulations which ordinarily regulate the conduct of human affairs, would do, or do something which a reasonable and prudent man would not have done. That is negligence. Under negligence, we have elements of negligence. Subtopic: elements of negligence. We write something small. The thought of negligence consists of 3 elements which a plaintiff must prove in any action based on negligence. So, element number 1, legal duty of care. Legal duty of care. 2, breach of duty. And 3, loss or damage. Loss or damage. So under that we write something. We start by legal duty of care. Subheading: the plaintiff must prove that the defendant owed him a duty of care in the circumstances. The circumstances must have been such that the defendant knew or ought to have known that acting negligently would incur the plaintiffs. Under that, there are some questions to ask yourself. Yes? No, sorry. The circumstances, I'm repeating, the circumstances must have been such that the defendant knew or ought to have known that acting negligently would incur the plaintiff, who owes another a legal duty of care. It's a question. Who owes another legal duty of care? Yeah? After that we write, whether a person owes another duty of care will depend on whether such a person could reasonably have foreseen injuring the other. Whether a person owes another a duty of care will depend on whether such a person could reasonably have foreseen injuring the other. So, standard of care. That's number 2, standard of care. As a general rule, the standard of care expected of the defendant is that of a reasonable man of reasonable prudence. This is a person who has the minimum information and knowledge necessary to act reasonably in any situation. Where professionals and experts are involved, the standard of care is that of a reasonably competent professional. The concept of reasonable man is an artificial concept developed by law to promote objectivity. It is independent of personal subjectivity and prejudice. Number 3, unforeseen plaintiffs. These are circumstances in which a defendant does not owe a plaintiff a duty of care. In such circumstances, the plaintiff cannot sustain an action against the defendant irrespective of negligence. So we continue. Those were under legal duty of care. 3 points that were who owes another a legal duty of care, and we have explained standard of care, and we have explained unforeseen plaintiffs. So number 2 element of negligence is breach of duty. The plaintiff must prove that the defendant acted negligently, thereby breaching the legal duty of care. The plaintiff must prove specific acts or omissions that part of the defendant. The plaintiff must adduce evidence to prove his case. However, in certain circumstances, negligence is proved without evidence. These cases are referred to as res ipsa requita, which literally means it speaks for itself. Res ipsa requita spells R-E-S, res, ipsa is I-P-S-A, requita is R-O-Q-U-I-T-R. This is a rule of evidence by which the plaintiff is deemed to have established negligence on the part of the defendant without adducing any evidence. So, sio lazima utoe evidence. Requirement of res ipsa requita. 1. Absence of explanation. 2. Such a thing does not ordinarily occur when proper care is taken. 3. The instruments or object which causes the harm was exclusively within the control of the defendant or his servants or his agents. So those are the requirements of res ipsa requita. And effects of the res ipsa requita are: 1. It provides prima facie evidence on the part of the defendant. It provides prima facie evidence on the part of the defendant. And 2. It shifts the burden of proof from the plaintiff to the defendant. And if the defendant's explanation is credible, the plaintiff loses the case. So those are the effects of res ipsa requita. And I think we shall stop there. Go through those notes. This topic is one of the most examinable topics. Read and read again. Have those notes on your fingerprints. Ukiulizwa swali lolote kutoka kwa hii topic, you can be comfortable to answer. You can be able to handle any question emanating from this topic. And I hope you will be very good to go. So, swali lolote likiletwa kutoka kwa row of thought, you'll be able to answer the question. So, next time, andika hapo wa subheading, tutaanza with loss or damage. Loss or damage. We shall start from there. So, thank you very much for your time. Na kama ndio unajiunga nasi, tumeendelea sana. So, fuata the previous classes, yeah, you catch up with us. And don't forget to subscribe. Please subscribe, like, share, comment, and I'll be very, very thankful. Thank you very much. Have a nice time. Thank you.